Welcome back to the Dershow. A lot's happened since the last time we met last week. As I predicted, and my predictions about law, as you'll remember, tend to be correct. As I predicted, Judge Aileen Cannon, the federal judge assigned to the Trump request to have a special master appointed, granted the request, turned down the government's silly arguments that, oh, there's no reason for this, we're able to monitor ourselves, we will guard the guardians, we'll appoint special people from the Justice Department, prosecutors, and they'll review for lawyer client privilege and executive privilege, and don't worry, they won't tell anybody, they won't wink or nod, just trust us. Well, Judge Cannon said, no, I'm not going to trust you. We're going to have an outside person review this. There are thousands of documents. She said, we've already found a couple of documents that this taint team said was not privileged that, in fact, are privileged. My biggest concern is I don't trust Justice Department officials not to communicate with other Justice Department officials. As I've said before, what if the taint team came up with a smoking gun, a privileged smoking gun to be sure, but a smoking gun, or some really juicy tidbit about former President Trump? Does anybody believe it wouldn't leak? Does anybody believe that the trial lawyers, prosecutors in the case would go to their graves not having learned about this? I don't believe it. I'm sorry, I don't believe it. And that's why a special master was absolutely mandatory. But if you read the New York Times story, this is the news story on the front page of the New York Times, the news story, and it reads like a government brief. It is not an objective assessment of the opinion of the judge. I've read the opinion, I know the law. It's not. It's an advocacy piece against the judge. Right in the first page, it says the order may ultimately serve only to delay the criminal inquiry. And then it says her ruling seemed to carve out a special exception to the normal legal process for the former president and to reject the Justice Department's implicit argument that Mr. Trump will be treated like any other investigative subject. And on and on and on and on. This is the New York Times. They receive Pulitzer Prizes every year. They do not understand the difference between their first page and their editorial page. Their editorials appear in news items on the first page. And I challenge anybody who supports the New York Times, read this article. Read this article. And they're good reporters. I know at least one of them. But the Times so skews the story. This is not an analysis of the judge's opinion. This is a criticism of her opinion and an acceptance of everything the Justice Department basically said. Yeah, it will delay the investigation. Nothing wrong with that. Nobody's about to indict anybody. We'll talk at some point in the future about what's called in the Justice Department the 60-day rule. They're not supposed to be revealing anything or coming out with any announcements or indictments within 60 days of an election for fear that it might affect the outcome of the election. Obviously, that rule was violated against Hillary Clinton. It may have cost her the election. We don't know. But James Comey's announcement that the investigation had recommenced and then his announcement that it turned up nothing was not 60 days. It was like 10 days before the election, in complete violation of the standards the Justice Department claims to be following. Now, it's not a rule. It's not a statute. It's not in the Constitution. It's just good practice. And we'll talk about that in the future, but for now, let's look at what this decision will do and why it's clearly the right decision. What it will do is it will hand over to someone, and the judge has to appoint her or him. Probably will be a former judge, maybe a former eminent lawyer of some kind. One of the letters I got said, I should be the one. No, I'm not going to do that. But some former judge who is not in the Justice Department, who doesn't have lunch with the prosecutors every day, who doesn't have to be screened off, who is independent, who's part of another branch of the government, the judicial branch of the government, the judicial branch that essentially has oversight over the executive and legislative branches. So we'll get somebody like that, somebody that isn't answerable to the Attorney General of the United States, who is trying this case, who's responsible for deciding whether to prosecute former President Trump. Some outsider will be making these evaluations, and they're difficult evaluations. I know, because I've been involved in situations like this, both in cases where I've represented people and in my own cases where I have these two cases, one against CNN and one against the woman who falsely accused me. And in those cases, there's great disputes about whether or not material is covered by the lawyer-client privilege. And I don't want the Justice Department making that decision. It would be as if I'm suing CNN and CNN gets to make the decision whether it's lawyer-client privilege. No, I shouldn't be making that decision. CNN shouldn't be making that decision. Each of us should have the ability to give input to whoever's making the decision, but it should be a judge or a special monitor, somebody who can be counted on not to have a bias, not to have a thumb on the scale of justice. When the Justice Department reviews matters in order to determine what can be used in a trial, they don't have a thumb on the scale. They have an elbow on the scale. And that elbow should be taken off the scale. That thumb should be taken off the scale. The pinky should be taken off the scale. Nothing should be on the scales of justice. Justice must be blind. And you can't have blind justice when the Justice Department is evaluating the Justice Department, who will guard the guardians. It's a complete violation of our system of checks and balances. Our whole philosophy of checks and balances is we don't trust. We don't trust one branch of the government to monitor itself. If we did, we'd have a parliamentary system. In England, the parliament monitors itself. That's all. Yeah. There's a court, but the court used to be part of the parliament. Now it's a little bit separate, not as separate as it is in the United States, where we have three independent branches of government, equal and coordinate. Equal. The judiciary is equal to the executive. Obviously, the president has more power. The Supreme Court can't declare war. Well, neither can the president. Technically, only Congress can declare war, but presidents have declared police actions in which many American soldiers have died. But they're not wars, just like the Iran treaty is not a treaty. Oh, no, it's not a treaty. It's just a deal. It's a deal among nations. It quacks like a treaty. It walks like a treaty. It smells like a treaty, but it's not a treaty because a treaty requires a 2/3 approval of the Senate. We can't get 2/3 approval, so we're going to call it something else. You know what it reminds me of? There was a great writer named Theodore White. He was a biographer of presidents and just a terrific writer. And he was the first journalist allowed to go to see Mao Zedong when the situation began to ease with the very, very Cold War at about the time that Kissinger and Nixon went to China. And so he was invited to a great banquet by Mao Zedong. And they brought out this enormous pig, roast pig, and put it on the table, and they start slicing it. And White said, "Oh, I thought maybe you knew I'm kosher. I don't eat pig." And Mao Zedong, without pausing, said, "In my country, I decide what animals are called. I hereby declare it to be a duck. Now you can eat." Well, that's what Biden has done with the treaty. I hereby declare it to be a deal, not a treaty. That's what previous presidents have done. President Bush. Oh, it's not a war in Iraq. Oh, don't worry about that. We're not declaring war on Iraq. Yeah, we're sending missiles and troops, and we're killing Saddam Hussein, and we're changing the government. We're doing all the things that happen in war, but I hereby declare it to be a police action. So Senate, please, House, don't intrude on my executive power. Well, you don't have executive power. It's the legislator's decision to declare war. It's the president's decision how to conduct the war. He's the commander in chief. But the framers of the Constitution would not have allowed the Iraq war to have been conducted without the approval of the Senate. The same thing is true with the other situations I've talked about, the Iran treaty, etc. So who will guard the guardians? And it's critical that there be outside guardians. And the judge was 100% right when she said, not only must justice be done, but it must appear to be done. She didn't mention this, but she talked about a former president. That's not the important issue. That's important, but it's not the important issue. The important issue is this is a potential future candidate for president against the incumbent president. If this was somebody who had announced formally, I'm not going to ever run again, if Trump had ever announced that, that would present a somewhat easier issue. But when you have the future potential nominee of the opposing party who wants to run against the incumbent who appointed the attorney general, yes, the appearance of justice has to be satisfied. And the appearance of justice is not satisfied when the attorney general of the United States gets to make decisions about whether the attorney general of the United States did the right thing when the attorney general of the United States authorized a search of Mar-a-Lago in violation of the attorney general of the United States' own statement that searches should be conducted only when there's no reasonable alternative. So yes, we need an outside person. Now, I hope she appoints a good outside person, and don't know who it will be, whether it will be a Democrat, whether it will be a Republican. That's going to be up to her. She has solicited advice from both sides, and it would be very interesting to see, let's assume the Trump lawyers come up with 5 names and the government comes up with 5 names. It would be interesting if one name was on both lists. I kind of doubt that's going to happen. That could have happened years ago when you had kind of Walter Cronkites of the law, consensus people who everybody believed was above reproach. I just don't think, I think we have such people today, but I don't think either side would concede that the other side may be correct in who it wants to see as the special monitor. And so in the end, the judge is going to have to look at both lists. She has the right to appoint somebody that's on neither list, but obviously it would be advisable to pick somebody. Now, that's a problem, because what if she picks somebody on one list but not on the other? So my suspicion is either there'll be somebody who's on both lists, and I can imagine David Souter being on both lists, Republican nominee to the Supreme Court, served for several years, not a long time on the Supreme Court, now lives in semi-retirement in New Hampshire, serves on the First Circuit Court of Appeals from time to time. Steve Breyer is probably too recently on the Supreme Court to be appointed, but there are circuit court judges. There are state Supreme Court judges who might be consensus candidates. But I hope whoever she picks is somebody who the public could have enormous trust in, because it's an important job. And I hope whoever does it has no fear of alienating the Justice Department. That person has to say, no. That document that was seized improperly. It's marked lawyer-client privilege, or it doesn't have to be marked lawyer-client privilege. If it contains lawyer-client privilege material, information transmitted between a lawyer and a client, even if it's not marked lawyer-client privilege, it is, in fact, lawyer-client privilege. And then there's this very difficult issue of executive privilege. I don't know whether the special master is going to be able to resolve that issue. Probably just alert the court to the issue. If former President Trump says on January 20th or January 19th, I did what Mao Zedong did, I declared it to be a duck, or what Biden is doing, declare it to be a treaty. And he declared it to be non-classified because he has the power to declare it to be non-classified, but he has to have done so. And that becomes an evidentiary issue. He can't say, oh, I thought it unclassified. I never unclassified it, but I would have, I should have, I could have. No, it's a question of evidence. Did he actually declassify it? And I don't know how the special master is going to deal with that. That's going to be a hard question because the president does have authority to declassify anything. I mean, would he? Of course not. No president's going to declassify the nuclear codes or the names of our spies in foreign countries. But I doubt very much that any of that is contained in the information that was seized at Mar-a-Lago. Why do I doubt it? Because if there was any suspicion that any secrets of that kind were exposed to enemy surveillance, they would have gotten a search warrant in February. And when they got the search warrant on Friday, they would have executed it within 5 minutes. I've had cases where the search warrant is issued at 4 p.m. and at 4:05 p.m., the search begins. How did that happen? Because the government knew it was going to get the search warrant. So they had their agents a block away, ready to pounce. And as soon as they got the phone call, search warrant has been issued, boom, in they went. They could have done that on Friday. By the way, search warrants don't observe Shabbos, Saturday. They don't observe Sunday. You can search on Saturday. You can search on Sunday, but no, they wait until Monday. If there were names of spies, if there were nuclear codes, if there were other kinds of secret information, they would have acted more quickly. That's not the reason they went for a search. The reason they went for a search is precisely to get information of the kind they got, which they couldn't have gotten for a subpoena. Because if they had subpoenaed material that was either declassified or which was covered by lawyer-client privilege or executive privilege, the other side would have said, no, we're not turning this over. This is lawyer-client privilege. Judge, you decide. But when you have a search warrant, that's not what happens. They just seize everything. You grab everything you can get. You grab everything that's within plain view. And we know that the FBI has developed incredible I'll get the word right. Peripheral vision. They can see out of the back of their head. I have to tell you, I've read search warrants and I've read search warrant responses, and it's just amazing what agents can see if they're determined to see it, because there's what's known as the plain view doctrine. If something is in plain view, if it just happens to be seen by an official who's doing the searching, even though it wasn't part of the search warrant, you can seize it. And so they often manage to see things through walls. But that's a search warrant. And that's why the Justice Department has as a general regulation that it doesn't conduct intrusive searches unless there's no reasonable alternative. Here, there was a reasonable alternative. And the Justice Department is furious because it may be undercutting the search warrant for a special master to go through all these documents and say, no, this you don't get, this you get, this we're going to submit to the judge, she'll decide whether you get this or not. So I think it's a great decision. I think it's good that it happened. The government may appeal it. They didn't indicate today whether they would or would not appeal it. They demurred, according to the New York Times. They have time to appeal it if they want to. Frankly, if they're going to appeal it, they better do it tomorrow. Otherwise, again, people are going to say, if it was so important, if you don't want a special master to look at these things, appeal it tomorrow. Ask for a special emergency session of the 11th Circuit. If they wait 14 days, which I think they have, or 10 days, I don't remember what the rules are on this, but a certain number of days, then the argument is going to come back, hey, you aren't really that anxious to do this. You're just appealing in order to see if there's a possibility of getting this thing reversed. If I were the government, I would not appeal. I would seek an expedited appointment of the monitor and give them all the material and get it moving. Now, nothing's going to happen between now and after the election anyway, so no harm, no foul. despite the New York Times' statement, ultimately to delay the criminal inquiry. It's not going to delay anything. It may delay some of the investigation. By the way, the judge's ruling said that the national security people can continue their review. If there's anything of a national security nature, nobody's stopping them. You don't need to get the approval of the special master to do that, because the national security people, their team tends not to be part of the prosecution, although, they can be close at times, but they have a focus not on winning the trial. Their focus is on protecting the national security more directly. Okay, so this is a work in progress. We're going to see what happens. We're going to see who she appoints. I'll obviously comment on that when that happens, and we'll see what the special master comes up with, and we'll see whether or not there's criticism of what was seized, and whether a lot of what was seized might be privileged. Again, the Times had pictures, because the government gave it pictures, of all the classified stuff that was seized. That's already been out there. Now, the special master may make a list of things that should not have been seized that was seized. So we'll get a sense, at least, of both sides of the story. Okay, let's get some questions in the last 10 minutes or so. Question number 1. There is no such thing as reasonable gun control. The historical documents are very clear on it. No, they're not. Again, let me read you from the badly drafted Second Amendment. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Okay, a little bit of history. There were contending arguments at the founding. Hamilton wanted there to be a standing army, the United States Army, the Navy, etc. Jefferson said, maybe I'll let you have a Navy, but no army. You're not going to have an army. We're going to have what won the Revolution, state militias, Concord and Lexington, all with state militias. I have letters that I've seen from Washington calling up this state militia and that state militia. A state militia. So if there is a state militia, if that's why we have a Second Amendment, because there are state militias, and the Constitution adds the words well-regulated, they could easily have just said a militia being necessary to the security of the state, the right, etc. No, they said a well-regulated militia. Doesn't that mean the state, not the federal government, has the right to regulate the militia? And doesn't that mean that the state has the right to reasonably regulate who has guns and who doesn't have guns, and how they can and can't be used? Do people really think that a state has to allow 10-year-olds to have automatic weapons? Of course not. And does anybody really believe that a state could allow people to own their own bazookas or weapons of mass destruction or rockets or poison gas or nuclear material? Of course not. There has to be some regulation. The question is always going to be one of degree. What regulation is fair? Can you have age restrictions? California passed a law saying people between the age of 18 and 21 can have a gun, but not a semi-automatic weapon. A federal court struck that down, saying that's unconstitutional under the Second Amendment. Wrong. That's not unconstitutional under the Second Amendment. That's perfectly reasonable. I don't know if it will be appealed or not. And we're going to see lots and lots of cases going up to the courts on what constitutes well-regulated and whether or not reasonable gun control exists. So the letter is just dead wrong when it says there's no such thing as reasonable gun control. Of course there is. Nobody would dispute the fact that 5-year-olds should not have loaded guns in their bedroom. And that's some degree of reasonable gun control. So the question, again, is what is reasonable and what is not reasonable? And that's something the courts have to determine, because the courts interpret the Constitution. The Constitution, the Second Amendment, cries out for interpretation. And even in the Heller decision and the more recent decisions, where the courts gave much power to gun owners and took away power from the states, obviously under the Second Amendment, a state can't ban all guns. That would be inconsistent. But the courts have said reasonable gun control, reasonable restrictions can be consistent with the Second Amendment, and courts have upheld some reasonable restrictions. I think they should go further. My view is that there should be different rules for rural and urban areas. There should be different rules for certain parts of urban areas. I think one of the hardest questions is if you have an extremely high crime area, where guns are used to kill innocent people, like in Chicago, whether or not a city can and should make it easier or harder for good people, innocent people who live in those neighborhoods to have guns for self-defense. I would think it should make it easier for people who live in high crime neighborhoods to have guns. But the answer to that might be, yeah, that people steal guns from innocent people, and so there'll be more illegal guns if there are more legal guns. I don't know the answer to that, but I can tell you one thing: the states ought to have more control over who gets access to guns, what neighborhoods have guns. When in Boston, Massachusetts, when I was living there, there was a very, very high crime area, and the police went in and just confiscated the guns, just had searches and confiscated the guns. Civil libertarians were concerned, but in the end, it reduced the crime rate very considerably. And most people agreed it was the effective thing to do. Was it consistent with the Fourth Amendment, because there were searches that were based on something short of probable cause? Was it consistent with the Second Amendment? Reasonable people could disagree about all of those issues, but what reasonable people can't disagree about is the empirical data that shows if you take guns away from criminals, there'll be less crime with guns. I mean, that's just a tautology. Obviously, that is true. Okay, next question. Professor, during the Civil War, Abraham Lincoln suspended the writ of habeas corpus and arrested some 30,000 people who were considered a threat to the Union. Prominent Democrat Clement I can't even spell it, Vallandigham, Vallandigham, was arrested and imprisoned for making an anti-war speech, obviously in violation of the First Amendment. Some of these people perished in jail. I don't know whether that's true or not, but it's very likely. In view of the hatefully divisive speech delivered by Joe Biden, is it not possible that Biden could try and do the same thing to the Republicans he obviously hates? Well, first of all, Lincoln's suspension of the writ of habeas corpus was declared to be unconstitutional by the Supreme Court. Congress has the power to declare martial law, not the president. The president can recommend a declaration of martial law, and maybe he can declare it like instantaneously if there's an immediate riot, immediate insurrection. Maybe he has some emergency powers, but the power to suspend habeas corpus over a period of time lies with Congress, not with the president. And it happened during the Civil War, which was a real insurrection. It wasn't January 6th. It was a real insurrection. We needed a civil war to resolve the issue of slavery. As I've said and continue to say, I often wonder whether Abraham Lincoln would have actually started the Civil War had the South not attacked Fort Sumter. I don't know the answer to that question. But what you have is a situation where the president felt he had to declare martial law. The Supreme Court, by the way, at the end of the Civil War, found that action to be unconstitutional. I've written extensively about the use of emergency power, so I'm very familiar with that particular action. Okay, let's see what else we have. Little by little, Dershowitz is leaning to the right. Maybe one day we can get him to vote Republican. I am not leaning to the right. I am exactly where I was 60 years ago. I haven't budged a centimeter. What's happened is the left has moved, and therefore I appear to be more on the right, but I haven't moved at all. I still maintain all the positions I maintained as a civil libertarian when I was 20 years old, 16 years old. I'm a advocate of complete free speech, of due process. I'm an opponent of the death penalty. I'm in favor of gay marriage and gay rights. I'm in favor of reasonable gun control. I haven't moved to the right at all. The left has just moved away from me, as Ronald Reagan put it when he left the Democratic Party. I haven't left the Democratic Party. They left me. And I feel like that sometimes. The difference is I can't join the Republican Party. If it were all Reagan Republicans, if it were the old-fashioned Republicans, the Rockefeller Republicans, if it were, for example, the woman who is today appointed to be the Prime Minister of England, of Great Britain, who is a moderate conservative. She's a conservative. She is what in England is regarded as the Republican Party, but it's not the Republican Party. The Conservative Party favors gay rights, favors reasonable birth control, favors reasonable gun control, opposes the death penalty, favors climate control. So it's not the Republican Party. So I can't join the Republican Party. You want me to join the Republican Party? Fine. Get the Republican Party to be like the British Conservative Party. I'll sign up tomorrow. Okay. See you tomorrow, where we'll continue this discussion and focus on some other very controversial issues as well. Good night.